Good morning, everyone. I'm Judge Jackie Powell, and we're in first appearance court. In a little while, I'm going to be telling you if I found probable cause based on these affidavits that I've already read, and then we'll also talk about release conditions. Today is not your trial date, so every morning I say when I come up here, do not talk about your case. Someone always says, Judge, I'm not talking about my case, but, and then proceeds to talk about their case. So I'm telling you today, don't talk about your case because everything in this courtroom is being recorded. Listen to your attorney. If you have one, in the courtroom, I do have the attorney from the Public Defender's Office, Mr. Brian Reedy, and over at the main jail, there is another attorney from the Public Defender's Office. Also, if you have a private attorney, they usually come to the courtroom and speak on your behalf. So check with your attorneys before you decide to speak on the record. We also have the attorney from the State Attorney's Office, Mr. Eric Linder, and I have confinement status and pretrial supervision services in case anyone will be released on those conditions. So when I call your name, I'm going to ask you to come up. I have, Mr. Reedy, has the jail asked for anyone to be called out of turn?
No, Your Honor.
All right, thank you. I do have one person who's signed in, so we can address that person. On page 6, we have Adria Evangelista. Good morning.
Come on up, there's your private attorney.
Good morning, Your Honor. Andy Coffey on behalf
Good morning,
of
Mr.
Ms.
Coffey.
Evangelista.
Good morning.
Good morning, ma'am. All right. So, Ms. Evangelista is before the court. I have read the probable cause affidavit, and I have found probable cause.
Understood.
So I'll hear from the parties in regards to bond.
Yes, Judge, for the record, her parents are here on the second row.
Good morning.
They started contacting me yesterday. I was actually on the phone with Mr. Griffiths yesterday trying to get to this point today. We did talk. He has agreed to a lesser bond. And Judge, I have the passport, which as soon as I'm done with Your Honor, I'll go get a receipt from the clerk's office and
Okay.
show proof that we filed it. Mr. Griffith and I have agreed to a bond amount, Judge.
All right.
Yes, Judge. State would be asking for count 1 and $2,000 per count.
Did you say two? 'Cause-
$2,000 per count? So
Okay.
$20,000. The court can just ROR on count 11.
Okay.
And then we would just ask for Elmo, level 2, no contact with minors, and no internet access.
Judge, because there is a 1-year-old at her house, she's going to be living with her grandmother, who lives about 5 minutes away from them. So we have a new address to provide to pretrial because the state doesn't want her moving back home because she's in the house.
Right, so she's gonna be moving in with the grandmother?
Yes, and I have the address if you need it for the record, or I can give it to pretrial.
Okay. All right, finding probable cause, counts 1 through 10. The bond will be $2,000 on each count. And then on count 11, per agreement, Ms. Evangelista will be ROR'd. The special conditions, she'll be on a GPS monitor, surrendering the passport, and no computer or internet use, and also no contact with minors, right?
Level 1, Judge. I think I said level 2. I meant level 1, at least the lesser restricted one.
Which is the lesser
No,
restricted.
level 2.
Sorry. I always
You think after all these years we would both
Yeah.
learn, and yet we don't.
No, that's okay, that's okay. It goes backwards.
You know what? If I remember it that way, I'll remember it. All right, Judge. Thank
All right.
you very much for your time this morning.
You're
Appreciate it.
welcome.
Nice to see you.
Same here. You have all the conditions right, I don't have to write them?
Oh, no, ma'am.
Thank
I got
you.
it. Thank you.
All right, let's go to the top of our docket. Santos Ortega.
He's here present, Judge at Maine.
All right, Mr. Ortega, you're before the court today for 1 count of aggravated battery causing bodily harm. I do find probable cause, and I'll hear from the parties as to bond.
Your
Your Honor, I would be requesting a $2,000 bond and an order of no victim contact.
Okay,
One moment, Judge, let me discuss something with Mr. Ortega.
Sure.
I believe you state that they're recommending 2,000.
yes.
Thank you.
Yeah, yeah. Just this. There you go. Where's the other one I had?
Judge, after consulting with Mr. Ortega, that's reasonable.
All right. We'll just stay with, the finding probable cause, the bond is $2,000. Good luck, sir.
And no victim contact?
And no victim contact.
Can I have a photo order as well, Judge?
Sure.
Thank you.
Jacob Domkowski.
Conti?
All right, sir, you're before the court. It's a change of charge from felony battery to battery second or subsequent offense. How much bond?
Judge Allspector originally set the bond at $5,000. I'd request that Your Honor keep the bond at $5,000 and order no victim contact.
All right.
It appears to be almost a lateral change, really.
That's
Yeah.
why.
I understand the state's position, and I know that we're not necessarily here to address that particular issue. Mr. Dombrowski, you going to be able to bond out?
No.
All right. You have a public defender?
Yes.
Have they been to see you?
No.
All right, I'll send an email to your PD, have them come see you, okay?
Okay.
All
good
right,
luck.
your bond is $5,000, sir.
Okay.
And then Jonathan Lopez,
Conti again, Your Honor.
looks like it's the same situation.
Yes, Judge. This is, well, it's actually an upfile from a misdemeanor battery to felony battery second or subsequent. I do
Yes.
know that Judge McHugh was aware of the previous battery when she set the bond, and she set the bond at $3,000. Your Honor, the reason I know she was aware of it is because he was on probation for that battery, and she ordered him to be held no bond for the violation of probation, so she was obviously aware.
Okay.
The only thing I would ask, Your Honor, is a new no contact order has to be issued, because the previous no contact order was issued on the misdemeanor case number.
All right, so the bond is going to remain at $3,000. No victim contact until further order of the court, sir.
In light of the fact that Mr. Ortega has a no bond hold on count one, Judge,
So you got it.
it's not Mr. Ortega, I'm sorry, Mr. Lopez has a no bond hold on count two.
Normally I just give males phones, but yours, you've been keeping them in order? Very good, because we'll be getting to your females.
Okay.
soon.
All right, so you'll be before your division judge later this week, sir, okay?
Thank you.
All right, Marcus Renfro.
He's here, President Judge Armani.
Mr. Renfro, you're before the court for me to advise you that there is an out-of-state felony hold. It's a no bond hold. And you should be going to extradition court. Extradition courts are held Tuesday and Thursday of each week. So I'm not sure if you'll get on for Thursday, but if not, then next Tuesday, okay? All right, good luck, sir. Arthur Melton.
He's your present judge.
Okay. Mr. Melton, you also have an out-of-state felony hold, and it's a no bond hold, and you should be going to extradition court as well as soon as they get you on that docket, okay?
Yes, ma'am. Good luck.
All right. Darlene Garand,
North Broward, Your Honor, Ms. Durand would like to resolve these matters today if possible.
all right, Ms. Garand, you're before the court for 2 counts of misdemeanor capias, and it's petty theft and suspended driver's license.
Yes, Judge, and she did turn herself in.
All right, and did you have that discussion about, is there any other petty thefts? priors?
No, Your Honor, I believe this is her first petty theft and her first suspended license charge. I did explain to her the consequences of subsequent arrests for these similar offenses.
Okay. All right. State, do you have an offer for Ms. Garand?
Yes, Your Honor. On the DWS, it's an adjudication time served. This is not her first DWS. She has at least one prior. The theft would be a withholding court cost.
Is that what you'd like to do, Ms. Garand?
For what?
If you want to resolve the cases today, it would be an adjudication on the suspended license charge, a withheld adjudication, no conviction on your record on the petty theft. Your sentence would be the time you've already spent in jail.
Do I get to go home today?
Yes.
Yes, I would. Yes, that's fine.
You have to pay court costs.
That's fine.
Okay.
Thank you so much.
Well,
nice
I'm not
day,
done
ma'am.
yet.
All right, Ms.
don't go
Garand,
too
hold
far.
on just a moment, okay? All right.
Sorry.
Please raise your right hand as best as you can. Just, you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Ma'am, do you understand everything that's going on here today?
Yes.
Do you need
ma'am.
more time to speak with your attorney?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
And you understand that you have a right to go to trial. By taking a plea today, you are giving up that right.
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
For a mental illness?
Have you ever, it's a question, have you ever been treated for mental or emotional illness?
Yes, ma'am.
Are you taking any medications today that would affect your decision making?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. As to count 1, which is a suspended driver's license, your sentence is adjudication and time served. And then on the petty theft, your sentence is a withhold adjudication and court costs. And I'll give you 6 months to pay your court costs. Good luck.
Thank you, ma'am. Have a nice day.
Okay, good luck.
Thank you.
Sydney Whitaker. Is she also? Oh.
He's here at main judge approaching.
All right, Ms. Whitaker, you're before the court for count 1 is disorderly conduct, and count 2 is resisting officer without violence. I do find probable cause, and I'll hear from
Judge,
the
Ms. Whitaker, after discussing her options, she advised me at this time she wishes to resolve it, so we wanted to know if the state had a plea offer for Ms. Whitaker.
Offer be a withhold court cost.
Let me relay that to her.
Okay.
She wishes to accept the state's offer, Judge.
All right, Ms. Whitaker, please raise your right hand as best as you can. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Ms. Whitaker, do you understand everything that's going on in the courtroom today?
Yes, ma'am.
And have you had enough time to speak with your attorney?
I don't need one.
Well, there's one standing next to you who's been...
Are you an attorney? I didn't even know that. Okay. Yes, ma'am. Yes, I've had enough time talking to him.
Okay, and do you understand that you have the right to go to trial and that by taking a plea today you are giving up that right?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, ma'am?
No contest? No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given, and your sentence is a withhold adjudication and court costs. Good luck. Andrea Lara Quinte.
Ms. Lara Quinte is in North Broward, Judge. She'd like to resolve this matter this morning.
All right, Ms. Lara Quinte, you're before the court. It's for a misdemeanor capias on a drug paraphernalia charge. Your attorney tells me that you wish to resolve your case today. Is that correct?
Yes, ma'am.
State, do you have an offer for Ms. Lara Quinte?
Not at this time, Your Honor. Ms. Laraquente asked to have her case transferred to drug court, and that's where the capias is out of.
Oh, this is out of drug court?
Yes, ma'am.
All right. Well, you get to go to see the drug court judge tomorrow at 8:30. So, since you're in drug court, you'll go and see that judge tomorrow, okay? Danielle Radford.
Danielle Radford is here at main judge approaching.
Ms. Radford, you're before the court for trespassing on occupied structure. I do find probable cause. What does Ms. Radford wish to do?
Judge, in speaking to Ms. Radford, discussing her options, we're going to be asking for an ROR. First, before I proceed, I want to know if the state has an objection to that.
That's fine, Your Honor, as long as I just asked an order of no return.
Well, we don't have a problem with that, but she did inform me she has her belongings there, so she would like to go one time with law enforcement to retrieve her belongings.
All right, I'll allow that one time. Maybe the hotel already has the belongings ready, but one time to pick up the belongings, and I'll ROR you on discount.
Thank you, ma'am. Thank you, Judge.
Andrea Lamorta.
Yes.
North Broward, Judge.
Ma'am, you're before the court for burglary on occupied dwelling unarmed. I do find probable cause. And I'll hear from the parties as to why.
Judge, I'm going to be asking for pretrial release.
Okay?
That's it?
No, I'm waiting for the state, ma'am, so hold on just a moment.
Sorry.
Good morning, Your Honor. The state is objecting. For the record, Jashama Augustin, Assistant State Attorney. At this time, the state objects to pretrial release. This was a offense regarding a home. In addition to, she was Baker-acted in Palm Beach last month. And at this time, the state is asking that the defendant receive a $7,500 bond. And no victim contact and no return to the location.
What priors does Ms. Lamarta have?
She has prior DUIs and also a theft out of Nevada in 2008 and 2009.
Okay.
Her most recent contact with law enforcement was over 10 years ago, Judge. She's been living here in Florida since then for the last 10 years. She has been staying at the Millennium Program. She's provided me with the number of her mom and the number of the program. They will welcome her back. And that's where she would go if released. She pays $525 a month in rent. Her mother assists in that. She also uses money from her tax returns for that. The fact that she was Baker-acted in the past really should not have a bearing on whether or not this court feels that she is appropriate for pretrial release. There's certainly no indication in the probable cause affidavit, as I read it, that there was any concerns of that matter. My conversations with her this morning did not cause me any concern about her mental health. The reason that she's wearing the green vest is because it is the jail's policy that if you've been Baker-acted in the past, they put the green vest on you. I think she'd be a good candidate for pretrial release in light of the fact that she has a lengthy ties to the community and that she has had no contact with the criminal justice system in 10 years, and that contact in and of itself were misdemeanor charges.
All right, I'm going to grant the pretrial supervision release with a level 2 GPS. And no return to this location. All right, Veronica Castaneda.
She's here at Maine, Judge. Judge, she declined the public defender's office.
Her bond is posted, is that right? All right, Ms. Castaneda, you're before the court for count 1, fraudulent use or possession ID of another person without consent. Count 2 is defrauding a financial institution. And count 3 is possession of counterfeit driver's license or ID. I do find probable cause, and I've been advised that your bond has been posted. Good luck.
Thank you.
Julia Feldman.
North
North
Broward.
Broward, I believe.
Good morning.
Good morning. Ms. Feldman, you're before the court for a felony capias, which is a no bond hold and not for magistrate. Count 2 is false ID given to a law enforcement officer, and count 3 is possession of drug paraphernalia. I do find probable cause. You will be going before your division judge tomorrow at 8:30, and your bond on count 2 is $100. Good luck.
Thank you.
I'll make that call for you, Julia.
Okay, thank you.
Jennifer Nushelli.
She's a medical researcher.
Okay. Grace Sherry Johnson. Yes, she's a medical research. Yes. Thank you. Ms. Johnson, you're before the court for count 1 is robbery with a weapon, and count 2 is possession of cannabis 20 grams or less. I do find probable cause.
Judge, I'm going to be asking for pretrial release for Ms. Johnson. She indicated to me that this is the first time she's been arrested. I know that this is a serious allegation. She has lived here in Florida all of her life. She's been living for the last 5 years with her mother and her sister and her 3-year-old daughter. She is a high school graduate. She's starting Broward College next semester. The weapon, involved, and I'm not minimizing anything, but the weapon involved here was a broomstick. I don't know exactly what happened. She's certainly agreeable to never return to that particular property. But I think that she would be a good candidate based on her lifelong ties to the community, no prior criminal history. I think she'd be a good candidate for a pretrial release.
Your Honor, first the state would be objecting to release the pretrial of first appearance on a first-degree felony. Your Honor, my understanding of the law, she's not even entitled to an ROR, to pretrial release supervision on this offense. If someone's robbing me and threatening me with a broomstick, I'd still be pretty concerned. You could do a lot of damage with a broomstick. Your Honor, I'd be requesting a $10,000 bond, no victim contact, no return.
Well, there's no indication that any damage was done with a broomstick. This is a pretty minimal type of probable cause affidavit for such a serious offense. It doesn't even say what it is that Ms. Johnson supposedly did with the broomstick to put the victim in fear. There's no statement from the victim saying that the victim was in fear. There's no language in here that indicates that Ms. Johnson raised the broomstick over her head or swung the broomstick at the victim or did anything along those lines. So we don't know those things. This court has discretion. And for someone with no prior record under these kind of facts, without knowing more, to keep her in custody at this point, Judge, again, I'd be asking for someone with no prior criminal history to allow this court to put her on pretrial release and release her.
And Your Honor, the last thing I'll say is, considering the court has found probable cause, and the allegations that she was robbing this the housekeeper of her key card, it's reasonable. Logic would dictate it's reasonable to believe that Ms. Johnson didn't have the broomstick to sweep up.
I do find probable cause. I am going to impose a bond of $5,000 and no return to this location.
I'll call your mom, Miss Johnson, okay?
Thank you.
Walter Smith.
Mr. Smith is approaching, Judge. You see that name? Good morning.
Good morning, sir. You're before the court for trespassing, failure to leave a property. I do find probable cause.
Judge, in speaking to Mr. Smith, he's looking forward to having his day in court and disputing these allegations. And Judge, at this time, considering this is a non-violent misdemeanor offense, we're going to be requesting that Mr. Smith be released to ROR. Now, he does live in Fort Lauderdale, with a friend. Right now, Judge, from what he has me, there's nobody that can post his bond. So that's why we are requesting at this time for having Mr. Smith be released to ROR, and he will be coming back to court and disputing these allegations, Judge.
Do we have any priors on Mr. Smith?
Just checking with you, Your Honor. He does have priors. He's been to state prison. I see he's had an injunction placed against him in the past. And he's had federal prior, drug offense, and multiple arrests for failures to appear in the past as well.
Judge, hold on. And speaking of Mr. Smith, he does realize, he did tell me up front, he has a past, he's been in prison, everything like that, but he advised me also, Judge, he's been clean for about a year. He's disputing the failures to appear. He advised me that the basis of those failures to appear were that he was in custody, so he didn't voluntarily miss. He wasn't transported to account for his court dates. He will be coming to court, Judge, so he's asking again, Judge, on this misdemeanor trespass for an ROR.
All right, at this time, I'm going to deny the ROR. Based on the allegations, this is not the first time that Mr. Smith is being trespassed from this property. I will, however, place him on standard pretrial supervision. He needs to report to pretrial within 24 hours of his release. Failure to do so will lead to your arrest. So get the information from the attorney and make sure that you show up and report.
Yes, ma'am.
Antoine Bird.
He's approaching, Judge.
All right, Mr. Bird, you're before the court. It's 2 counts. It's 3 misdemeanor KPS matters. Looks like you failed to appear in court on January 24th. It's leaving the scene of an accident, driving while license suspended, So I do find probable cause.
Judge, our first request, and speaking of Mr. Bird, he wishes to see if the state has a plea offer on this case.
Not at this time, Your Honor, based on the nature of the offenses, leaving the scene of an accident with the DWLS.
And that's what I told Mr. Bird. Most likely they wouldn't have a plea offer here, especially at magistrates. Judge, the only thing I'm going to ask for the court to consider is he realized he had a court date January 24th. Unfortunately, his sister passed away. That's why he didn't show to court. He advised me he turned himself in. He advised me he came to the main jail.
Sunday night. Well, Monday morning I turned
No, I see that. That's what it says, that he surrendered. So.
Judge, so, I mean, we're asking if the court will consider an ROR.
Your Honor, on the 2017 case, there's been two. It looks like this is at least the third capias that's been issued on this case for failure to appear. Certainly, I'm sympathetic and sorry for his loss, but this missed court appearance was over 2 months ago. And I understand he turned himself in now, but he had 2 months to turn himself in.
Judge, at the end of the day, he did the right thing.
All right, are you saying that there are previous failures to appear on these cases?
Yes.
How many times?
This is at least, on the 2017 case, this capias was at least the third capias that was issued for failing to appear.
All right. That would probably explain why the bonds are 2,000, 1,500, and 2,000. I'm gonna leave the bonds in place. Good luck, sir.
Judge, would you be inclined, I know we requested an ROR, and the court has ruled and said no. Would you be inclined, considering he did turn himself in, Judge, would you be inclined to release him on pretrial release?
We can do level 2 pretrial.
We appreciate it. Thank you, Judge, but we'll leave the bond the same. He'll go to court.
I suspect that was gonna be the response. Darren Davis.
Maybe it's a medical loan, Your Honor.
Okay. Myquavis Singletary.
He's approaching, Judge. Here, me.
Mr. Singletary, you're before the court for a touch or strike battery. I do find probable cause. I'll hear from the parties as to bond.
Your Honor, I'm going to be requesting a $2,500 bond based on the allegations, not just the battery against the victim, but according to a witness, he went after her at the vehicle of her car. He nearly broke the door of her car off. And the victim required stitches for the injuries he suffered from the battery.
Okay.
Judge, from what Mr. Singletary, he can't even afford the $1,000, which is currently set, let alone what the state is asking for as far as a bond increase. He's 24 years old, been living in our community now for over 12 years. Right now, he's currently looking for work. He lives with his uncle. His uncle does landscaping for a living. From what he advised me, no one's going to be able to afford to post his bond. So we're requesting on this misdemeanor offense, Judge, the court release him on pretrial release.
All right, the allegations in this affidavit are a little bit alarming, and even though it's a misdemeanor, there are lots of things going on here. I do find probable cause. I'm going to leave the bond at $1,000.
No victim contact?
No victim contact.
Thank you.
Lucio Quinteros Calles.
Good morning, Judge. Mr. Quinteros Calles is here. If I could just have a brief moment to speak with him. But if I could also find out what the state's offer would be to resolve this case if he wants to.
Time served.
Okay, thank you.
All right. Tajay Edwards.
Mr. Edwards is here at Main, Judge.
Mr. Edwards, you're before the court for misdemeanor capias on petty theft and a possession of cannabis. You failed to appear in court on March 19th. I do find probable cause, and I'll hear as to bond. There are bonds that are in place on the capias of 1,500 on each count. So I'll hear from the parties as to bonds.
One moment, Judge. Judge, in speaking Mr. Edwards, he wishes to ask the court if there's a plea offer on this case from the state.
Okay.
Offers withholds on both counts. No return to the Coles involved in the theft.
No return to Coles.
Yeah, Kohl
Okay.
apostrophe S.
Let me advise, Mr. Edwards.
You're not able to get on the saves. Go saves. Yeah, I got it.
Judge, he wishes to accept the state's offer.
All right, Mr. Edwards, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. Mr. Edwards, do you understand everything that's going on here today?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you know that you have the right to go to trial by taking a plea today? You are giving up that right.
Yes, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you are not a U.S. citizen, by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, Mr. Edwards, what plea do you wish to enter?
Sunday.
What's the judge know? I would like to plead no contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is a withhold adjudication and court costs. And as to the theft charge, no return to Coles. Do you understand that, sir?
Yes, ma'am.
All right, good luck. Daniel Montague.
Please approach the judge.
Mr. Montague, you're before the court for a misdemeanor capious matter on a operating with a suspended driver's license, and it says second offense. I do find probable cause.
He wishes to resolve this case, Judge.
All right.
Offers withhold court costs.
All right.
Judge, he wishes to accept the state's offer.
All right. Mr. Montague, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, sir, you can put your hand down. And do you understand everything that's going on here today, sir?
Yes, ma'am.
Have you had enough time to speak with your attorney?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you understand you have the right to go to trial, but by taking a plea today, you are giving up that right?
Yes.
And have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, by taking a plea today, it could subject you to deportation or immigration changes?
Yes, ma'am.
What plea do you wish to enter, sir? Guilty or no contest?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is a withhold, adjudication, and court costs. Good luck, sir.
Good luck, sir.
Is William Green here today?
I'll check.
Okay. Mario Madrid.
Judge, Mr. Madrid is here present. Now, he did decline the services of public defender, Judge, but he wanted to ask for a phone order. Just letting you know, Judge.
All right. Mr. Madrid, do you have an attorney that you are going to hire?
No.
Sir, do you understand everything that's going on here today?
Yes.
And do you need a Spanish interpreter?
No.
All right. And so you have declined the services of the public defender's office. Is that correct?
Yes.
All right. You're before the court today for count 1, DUI, alcohol or drugs. Count 2 is DUI with damage to property or person. Count 3 is leaving the scene of a crash. And count 4 is improper left turn. That's a traffic infraction. I do find probable cause, and I'll hear from the parties. That means you and the state in regards to setting a bond.
Your Honor, considering this involved a crash and the allegation that Mr. Madrid left the scene of the crash, I would argue to avoid apprehension, I'd ask that the court keeps the $1,500 bond in place.
Okay. Mr. Madrid, is there anything you wish to say in regards to setting your bond?
No.
All right, so your bond on count 1 is $500. The bond on count 2 is $1,000. Good luck, sir.
Good morning, Judge. Could we recall Mr. Quinteros Calles?
Okay.
Mr. Judge, and he's on page 11 of the docket.
What was the offer from the state?
Adjudication time served, Judge.
Was he accepting that offer?
Yes, Judge, he is.
Okay. All right, Mr. Quinteros Calles, please raise your right hand as best you can. Do you swear or affirm to tell the truth?
Yes.
Okay, you can put your hand down. Sir, you understand everything that's going on here today?
Yes, ma'am.
Have you had enough time to speak with your attorney?
Yes.
Are you under the influence of drugs or alcohol?
No.
And do you understand that you have a right to go to trial? By taking a plea today, you are giving up that right.
Yes.
Is anyone forcing you to resolve your case?
No.
Have you ever been treated for mental or emotional illness?
No.
And do you understand, sir, that if you're not a U.S. citizen, by taking a plea, it could subject you to immigration or deportation changes?
Yes.
What plea do you wish to enter, Mr. Quinteros Calles?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given, and your sentence, sir, is adjudication and time served. Good luck.
Thank you, Judge. Judge, can I call just one more?
Maybe. Who is that person?
It's Cameron Huth. He's on page 16 of the docket, Judge. H-U-T-H.
Okay. All right, Cameron Huth. All right, Mr. Huth, you are before the court there are 2 misdemeanor capious matters, and then count 3 is a felony violation of probation, and count 4 is a misdemeanor capious. So I do find probable cause. The felony VOP is a no bond hold, and then there are bonds attached to the other misdemeanor capious matters. And he has court in the next 3 days, tomorrow, Thursday, and Friday, on all these.
Right. So, Judge, he realizes that he has court coming up on the violation of probation matter.
Yeah.
He also recognizes that his misdemeanors occurred before he was placed on probation. He was placed on probation in October of 2018. The misdemeanor petty theft occurred June of 2018, and he indicated to me that the misdemeanor occurred before he was placed on probation as well. He also indicated that he would like to resolve these misdemeanors so he doesn't have to worry about them, and he'll just go and face the music as far as his felony violation of probation matter is concerned.
Judge, that is correct. On the state misdemeanor offenses, he did advise me that those happened before he was placed on probation, October 15, 2018. So he does, if the state has a plea offer regarding those 2 counts.
He was placed on probation when?
October 15th.
I got it.
2018.
State, did you have an offer for Mr. Huth?
The offer from the state on 1 and 2 will be an adjudication time served.
Okay. All right.
Judge, in speaking, Mr. Raguth, he wishes to accept the state's offer regarding count 22.
All right, Mr. Huth, if you wish to resolve your case today, it'll be the same sentence offered for 4. So you'll be resolving the 3 misdemeanor matters today. Is that correct?
Yes.
All right. Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
Okay, you can relax. Have you had enough time to speak with your attorneys?
Yes.
And you understand you have the right to go to trial by taking a plea today? You're giving up that right?
Yes.
Do you need more time to speak with the attorneys that you have?
No.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
And do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter?
No contest.
All right, I accept your no contest plea. Find that it's freely and voluntarily given, and your sentence is adjudication and time served. Good luck.
Thank you, Judge.
You're welcome. That's only as to counts 1, 2, and 4. Just for the record, yes. Miguel Romero.
Conti advises me that Mr. Romero is in courtroom 6780.
All right, so we'll reset Mr. Romero. Patricio Arancibia.
He's approaching, Judge. Is here at me. Come on up, sir.
All right, good morning, sir. You're before the court. Count 1 is misrepresentation of payroll or class workers. It's a workers' compensation fraud. And then count 2 is obtaining property over $50,000 by fraud. And so I do find probable cause, and I'll hear from the parties as to bond. Well, Judge.
It's like Tim Bailey, Your Honor.
Judge Tim Bailey signed the affidavit and the warrant. On March 27th, 2019. And those were issued with no bond holds.
Yeah.
And, yeah.
Thank you, Your Honor. I know Your Honor's findings in the booking says obtaining property over $50,000, but looking at the affidavit and the very last sentence of the affidavit, it would appear that this is a fraud that was over $100,000.
Okay.
Your Honor, I'm going to be requesting a $25,000 bond on count 1, a $150,000 bond on count 2, the first-degree felony, organized scheming to defraud, pretrial release with a GPS monitor level 2. I'm going to be requesting that for a passport surrender prior to Mr. Arancibia's release. And I'm also going to be requesting a nebia requirement and full collateralization on both counts. I would note, Your Honor, that Mr. Arancibia's company between April 12th and December 8th of last year cashed over $4 million in business-to-business checks. Based on if these amounts had been reported accurately, his workers' compensation premium would have been an additional just under $400,000 up until this day, up until the date of this that the warrant was signed. He'd paid just under $6,000 in workers' compensation, his premium for his workers' compensation insurance.
Okay.
Judge, From what the state is suggesting as far as their bond request, $175,000 plus the special conditions, something that Mr. Arancibia, from what he informed me, cannot possibly afford. So therefore, he wouldn't be able to make that. He would be with us here at the Broward County Main Jail. I'm going to be asking the court to consider as a $5,000 bond on count 1, $5,000 bond on count 2, and have him supervised on pretrial release. He's been living here in our community for the past 20 years. He is a U.S. citizen, and this is his first arrest. He is a registered voter here in Broward County. His daughter goes to school here. He lives with his wife and daughter. She's 18 years old. They live in Tamarack, where basically they own their home. They have property here, and the mortgage is at $1,250. His wife does work. She's a hairstylist. Judge, now he was unemployed. He just managed to get another job, and he's going to be working for a company called Horner Express, where he's going to be a truck driver, Judge. Now, he does own property. He has a Honda Civic 2015, has approximately 55,000 miles on it, and he pays $476 a month for it. Judge, where he's living, where he was, I believe, arrested at his place, and what he's driving around, there's no way that he can possibly afford these. I didn't hear anything as far as to indicate that he's a flight risk. So from what the state is testing is a passport surrender and nebula hold, I believe is an overkill, considering they haven't mentioned anything that he's a flight risk or anything like that. I just explained to the court his strong ties to the community. So Judge, I'm going to be asking, like again, $5,000 on 1, $5,000 on 2, $10,000 with pretrial release on Mr. Aransabia's behalf, considering this is his first time being exposed to the criminal justice system.
All right, the allegations in these affidavits are pretty serious and concerning. There is workers' compensation fraud, organized fraud to defraud, and based on this allegation that the workers' compensation fraud alone is in the dollar amount of over $100,000. And so I find that a reasonable bond on count 1 is $25,000. And on count 2 is going to be $100,000 with the nebula requirement and GPS monitor.
Your Honor? Yes. Just so I know what to put in the order, is the court also ordering full collateralization with the nebula?
Yes. I'm actually writing it, but you prepare
I'll prepare an order
Yes.
for the court. And the court's not ordering a passport surrender?
Well, there is an indication that he is a U.S. citizen. I can take testimony from Mr. Arancibia. I'll just say that he cannot apply for a passport.
Your Honor, the concern is...
I don't mean to mislead the court. He does have a passport, but he is a U.S. citizen.
I will surrender his passport then.
Once again, Judge, I'm going to just be objecting. There's no indication at all with the state proffered today that he's a flight risk.
And, Your Honor, I just want to, for record purposes, it does note that his original place of birth was Argentina. He is facing a first-degree felony, punishable by up to 30 years in state prison. I think it's reasonable to believe, and now I understand Mr. Romero has advised the court of his assets in paper, but it is a reasonable concern based on these allegations that he could have cash resources that wouldn't necessarily be, there wouldn't be evidence of on paper, especially considering these allegations.
Hey, I was born in Ireland, so I don't think where someone's born should be the determinative factor.
All right, we don't need to go down that road. Based on this the allegations in this affidavit, again, you know, there's allegations that Mr. Arancibia said he only had 5 employees, and then that his company, you know, the dollar amount that his the policies that he took out, but then that the same company cashed over $4 million. So there's a lot of other things that are there And based on that, that's why I'm setting the bond at the amount and putting the requirements that I've placed as to release. Charles Kokusa.
Mr. Kukuza is here present.
All right. Sir, you're before the court for count 1, trafficking cocaine 28 grams or less. Count 2's possession with intent to sell, manufacture, deliver cannabis. Count 3 is selling misbrand in lieu of the scheduled drug. And count 4 is felony violation of probation. Count 5, 6, and 7 are also felony violation of probation. Out of Monroe County, it looks like there's one violation out of Monroe County. I do find probable cause. And, as far as the Broward violation of probation, you'll be before your judge tomorrow at 8:30. And count 1 does have $15,000 bond, count 2 $1,000, count 3 $1,000. And I will leave those bonds in place. The other counts are no bond holds. Good luck, sir. Bryant Echevarne.
Please approach the judge. Come on up, sir.
Good morning, Your Honor.
Good morning, sir. You're before the court for possession of cocaine and possession of cannabis 20 grams or less. I do find probable cause.
Judge, nothing to add from the defense. I'm going to be contacting his family after court.
All right. All right, the bond is $1,000. Jadida Walker.
Mr. Walker, come on up, please. Mr. President.
All right, Mr. Walker, you're before the court for count 1, possession of heroin, and count 2 is an out-of-state felony hold. I do find probable cause. Count 2 is a no bond hold for the out-of-state, and count 1, the bond is $1,000. Gary Swanson.
He's approaching, Judge. Come on up, sir.
Mr. Swanson, you're before the court for battery on a person 65 years or older. I do find probable cause, and I'll hear from your attorney as to setting a bond.
Mr. Mayor, you can go. I mean,
okay, no problem. Judge, in speaking to Mr. Swanson, we're going to be requesting a $1,000 bond. He's 66 years old. He gets Social Security. He gets approximately $795. He's a registered voter here in Broward County. He lives in Lighthouse Point by himself. where he's been living there for the past 3 years. He did give me the phone number of his girlfriend, who I intend on calling after court. She is also on Social Security. It's not his first time, not his first contact with the criminal justice system, but it's been quite a while. So, Judge, I'm going to be asking for a $1,000 bond on his behalf.
Your Honor, the state is requesting a $5,000 bond. He was convicted in 2009 for aggravated stalking, and this is concerning in addition to the type of offense that we're facing today. Further, Your Honor, we're requesting that the defendant has no victim contact.
Judge, I believe what the state forgot to mention is the prior happened back in, I believe, 2005.
No, they mentioned that.
Oh, I didn't hear that. Sorry.
The aggravated stalking was from 2009. The 05 that Mr. Romero is referring to is a battery, which we didn't advise the court of.
Okay. All right. At this time, I'm going to impose a bond of $1,000, no victim contact.
Thank you, Judge.
Thank you.
Brendan Applegate.
Mr. Applegate, come on up, please.
Thank you.
Judge, he informed us he has private counsel. What's his name? Mr. Michael Roque.
Yes, Judge, I spoke with Mr. Roque. He is, I believe, beginning a trial. Did not believe he was going to be able to attend court here this morning.
All right. Your attorney, sir, is not able to come to court this morning. So you are before the court for count 1 is a possession of heroin, and count 2 is introducing contraband into detention facility. Counts 3, 4, and 5 are felony violation of pretrial, and those are no bond holds and not from magistrate. So the bonds on counts 1 and 2 are $1,000, and you'll be in touch with your attorney as far as the felony no bond holds. I don't have a court date. I don't know when the court date, what date you'll be going to court on those at this time. All right? Okay, good luck, sir. James Crowley.
Mr. Crowley is approaching, Judge.
Mr. Crowley, you're before the court for 1 count of petty theft. And I do find probable cause. What does Mr. Crowley wish to do?
Judge, we're going to be asking the court to consider releasing him on pretrial release. Judge, he's been living in South Florida for 30 years now. He's 58 years old. He works as a handyman. He averages about $100 a week. He lives in Pembroke Pines with his parents, and from he informed me, his parents are on Social Security on a fixed income, so they're not going to be able to afford to post a bond. That's why I'm asking the court to consider releasing him on pretrial release on this petty theft offense. Felony petty theft offense.
Your Honor, the state would like to inform you that the defendant has an active warrant out of Dade County for a theft, for failure to appear. He was released from state prison on April 3rd, 2018. And that was for 2 separate felony thefts out of Broward. He has another felony theft out of Broward in 2014, 2013, 2012, and 2011. Again, Your Honor, another 2011, another 2011, a 2010, 2010. Now, these are misdemeanors, Judge, another 2010. He has a trespass of in August 2010. Another felony theft, 2010, 2009, 2008, 2008. And Your Honor, it just continues.
All right, I find probable cause, and I'm gonna leave the bond in place at $750. Good luck, sir. Benjamin Lamar.
Please approach the judge. Come on up, Mr. Lamar. Mr. Lamar's here.
Mr. Lamar, you're before the court for possession of cocaine and possession of drug paraphernalia. I do find probable cause.
Judge, we're going to be asking for the court to consider releasing Mr. Lamar ROR, or in the alternative, if the court's not inclined, we'd ask for him to be released on pretrial release. And speaking of Mr. Lamar, he's 56 years old. Judge, he gets disability, he gets approximately $800 per month. He does have priors, but he's been telling me that he's been clean for over almost 20 years now. So, Judge, considering this is a nonviolent offense, that is why we're asking if the state can confirm that in ROR, and the alternative, if not, then pretrial release.
It's not even close to 20 years. 2012, Dade County, tampering evidence. He's gone to prison in another state, getting hits out of New York, hits out of Alabama.
In that case, Judge, we're going to be asking pretrial. Financially can't afford, he's homeless. There's no one going to be able to post his bond, so I'm going to ask for the court to release him on pretrial release where he can be supervised.
All right, I'll release Mr. Lamar to pretrial supervision with random drug testing. Stephen Morganti.
Here he is, Judge.
All right, Mr. Morganti, you're before the court, driving while license suspended. Count 2, attaching registration license plate not assigned. Count 3, failing to register motor vehicle. And then counts 4 and 5 are felony violation of probation. Those are both no bond holds. You'll be before your division judge tomorrow at 8:30, and the bond on count 1 is $100. Good luck, sir. George Moore.
Mr. Moore's approaching, Judge.
Focusing on the next thing.
Mr. Moore is before the court for possession of drug paraphernalia, resisting officer without violence. Counts 3 and 4 are felony capias. Those are no bond holds and not for magistrate. So your bond, sir, on count 1 is $100, and you'll be before your felony judge tomorrow at 8:30. Good luck.
Good luck, sir.
Danny Briggs.
He's approaching, Judge. He's here.
Mr. Briggs is before the court for count 1, grand theft, and count 2, possession of drug paraphernalia, and I do find probable cause as to both counts.
Judge, we're going to be requesting the court consider releasing Mr. Briggs on a standard pretrial release. He's 32 years old, been living here for almost 7 years now. He's living in Navy at a halfway house. He's been there for about 3 months. He pays approximately $160 per week at that halfway house. He is self-employed. He's a painter by trade, and he gets approximately $250 a week. So as you can see with the math, he doesn't really have the resource to post bond. So I'm going to be asking the court to consider releasing him on pretrial release.
I'll hear from the state.
Your Honor, I would like to advise you that he has a lengthy criminal history in the state of Texas. and prior thefts. In addition to that, the state is asking for a $1,000 bond, and also no return to the location, and also, okay, that's it, Your Honor.
Okay, Mr. Briggs, your bond is $1,000 and no return to Home Depot in West Park, Florida. Winston Gray. Mr. Gray, you're before the court today for count 1 is robbery, no firearm or weapon. And count 2 is violation of parole. I do find probable cause, and I'll hear from the parties.
Judge, Mr. Gray knows the court cannot do anything in regards to count 2. However, on count 1, I see the bond, $100,000. That's something that Mr. Gray cannot possibly afford. He works in construction. He gets paid on a daily basis whenever there's work, and gets anywhere from $75 to $80. He lives with his mom in West Park. His mom is retired and on a fixed income, receiving Social Security. Now, he tells me he doesn't own any property, he has no money in the bank. So financially, a $100,000 bond is impossible for him. So we're asking the court, reducing it to $10,000.
Your Honor, we're asking that the bond stay in place as he is on parole, and this is another violent felony. We're also asked, one moment, Your Honor. Also asking for no victim contact and also no return to the location.
All right. The allegations here are that Mr. Gray entered into a doctor's office while with a patient and took money from them. There's also fingerprint evidence that was found. And so based on those allegations, there are concerns for the community. And so I am going to leave the bond at $100,000, and he'll be before the parole board on his violation of parole matter. And no return. Markeith Yarbo.
He's here, present, Judge May.
And his aunt is also present, Your Honor.
Good morning. Good morning, Ms. Richards. All right. Mr. Yarbo, you're before the court. Count 1 is robbery, no firearm or weapon. And count 2 is aggravated battery causing bodily harm. I do find probable cause, and I'll hear from the parties.
Thank you, Judge.
You can go ahead, Mr. Romero. I'm waiting on Mr. Linder, but you can go ahead in the meantime.
Oh, Judge, let me tell you a little bit about Mr. Yarbrough. He's 21 years old, been here his whole entire life. Graduated from West Park High School, class of 2015. He's been working since he's been 16 years old. He's been working at Wendy's, and he's ascended all the way. Now he's the manager there. He's making about $13 an hour. He lives in Sunrise with his mom, and his mom is a single mother, supporting him and his 8 siblings. Judge, my understanding is mom works at night, and she works with the city bus. Judge, as I stated, this is, from what he advised me, his first arrest. He is a registered voter here in Broward County. He's a little bit confused as far as his allegations. Judge, we're requesting, if the state can confirm, that he's had no prior contact. We're requesting a $2,500 bond on count 1, $2,500 bond on count 2.
Your Honor, he does have a juvenile record, but frankly, even if he had no history, I'd be making the following request. I'm requesting a $25,000 bond on each count, pretrial release with a GPS monitor, no victim contact, and no contact with, no witness contact. Your Honor, I'm very concerned about the allegations in this report, starting with the allegation that Mr. Yarborough and the other men that were involved in this followed the victim from a laundromat to his home, brutally attacked this man in front of his wife, beating him into unconsciousness, and then, while he's unconscious, going into his pockets and stealing his property, stealing cash. One of the men involved punched the victim's wife while she just tried to stop her husband from being attacked. Your Honor, frankly, I am concerned about the level of brutality described in this affidavit.
Okay.
Ma'am, are you going to be able to make that kind of a bond for him?
Basically, the reason why we would ask for a lower bond is because the allegations are not correct at all. The situation that they're speaking
All right,
of,
Let's not talk about the facts of the case.
We're not
The
going to
judge has
hear
already
about the
found
facts of the
probable
case.
cause.
The decision I have to make today is whether probable cause exists to detain him on these charges that have been presented. And my determination is based on this affidavit that has been presented to me. So that's what I make my decision on today. From here, he's going to go to a division judge, and if there's any motions to dismiss or to suppress that needs to be made, that will be heard at another time. But based on the affidavit that's been presented to me today, there is concern for the safety of the community, and I believe that at this time that a bond of $25,000 on each count is reasonable, with GPS monitor, no victim contact, and no contact with the other co-defendants in this case, until further order of the court.
And, Your Honor?
Yes.
Just in abundance of caution, I would just ask that there be no contact also with Malene DeFrand. She was a witness to the incident. So what's going on with him?
Denzel Samuels Hines.
Judge, I've been appointed bonded.
Thank you. Do we have Kirby Telseen today?
No, Your Honor. DSO PICS indicates he's still on medical loan.
Okay. And how about Eddie Rancher?
They didn't bring him, so he might very well be a medical reset from North Broward.
Okay. Ethan Hopkins?
He's a medical loan also.
Okay. Julian Riles?
Main jail.
Yes.
He's here, Judge, I mean.
All right. All right, does Mr. Reed, do you have a copy of this affidavit?
It's on us.
Okay, so, Mr. Riles is before the court for, it's on a it's a change of charge,
It's a down file, Your Honor.
okay? It's been down filed from,
Attempted murder to aggravated battery.
okay?
One moment, Judge.
All right, so I do find probable cause for the aggravated battery.
Your Honor, the state is going to be requesting a $100,000 bond, pretrial release with a GPS monitor. I believe, I don't know if it was already issued. Just in case it hasn't been, I'd be requesting an order of no contact. I would note, first off, just based on the allegations, that Mr. Riles allegedly stabbed the victim 4 times, had to be transported to the hospital. This was witnessed by the victim's girlfriend, who identified Mr. Riles and provided a sworn statement. I would note Mr. Riles is being held no bond at this time on a separate grand theft auto that he was out on release when this allegedly occurred. He's also has pending right now another grand theft auto. He has priors for exposure, felony battery due to priors, another felony battery due to priors, violation of a protective injunction, which causes concern as there's going to be a no contact order, and it does not appear that these 2 individuals are strangers. Battery on a law enforcement officer, violation of a domestic violence injunction, another violation of a domestic violence injunction, and battery.
Okay,
No, I'm under.
Judge, we're gonna be requesting a $10,000 bond on Mr. Rao's behalf. He's been in custody now almost a month. He's self-employed. He's a handyman. He's 42 years old. He lives in Fort Lauderdale with his girlfriend. Their monthly rent is approximately $800 per month. She works for a telecommunications company and customer service. So financial resources are limited. So there's no way him nor his girlfriend are going to be able to afford what the state suggests as far as $100,000.
all right. At this time, I'm going to impose a $50,000 bond, no victim contact with level 2 GPS. Good luck, sir. Eric Sapp.
He's coming up, Judge. Mr. Sapp, come on up.
Mr. Sapp, also, it's a change of charge,
Yes, this is really more of the
lateral change.
technical variety, yes.
Okay.
Your Honor, when he first came through, Your Honor found proof evident or presumption great for burglary with assault or battery. We filed it as burglary of a conveyance with assault or battery, but it's still the same offense.
And
I'm sorry. You'd found proof evident or presumption great, ordered him to be held no bond.
okay.
Your Honor, I'm sorry, hold on. If I could just have, I'm sorry, one moment. I just want to get this right. Yes, you did. You handled this first appearance.
All right.
Judge, Mr. Sapp advised me as private counsel, Mr. Bill John.
Okay. All right. Let me recall Mr. Sapp, and let's do Kendrick Moore. And if we can see if we can find Mr. Gillen, or if he intends on coming to court. Is Mr. Moore there today?
I've been advised right now, he's in regular court, 4780.
Okay,
I apologize, Your Honor. On Mr. Sapp's case,
yes.
19-3079 CF10A, the Public Defender's Office has filed a notice of appearance.
Okay.
Let me just confirm that with you.
All right. I'm just going to take a brief recess. You figure it out who represents him Heard, Eric Sapp,
Yes, Judge. He's approaching, we're ready to proceed.
okay.
Judge, I spoke with Mr. Jellin. He indicated to me that Mr. Sapp's family has not, they were supposed to come in yesterday, but they did not, and they were supposed to come in sometime today. But as of this point in time, they have not retained Mr. Jellin. So Mr. Jellin, I believe, is aware that Mr. Sapp has a court date tomorrow. And if they retain him today, he'll be there tomorrow for Mr. Sapp.
Okay, all right, so we were talking about the bond that, what conditions was previously set?
Your Honor just found proof evident of presumption great, order him to be held no bond, and order no victim contact.
Okay. So at this time, we'll leave those conditions in place with the previous findings, and of course, that's without prejudice. He can have his author hearing before his division judge, okay? All right, does that bring us to the end of our docket?
You have a perfection.
You have
Kendrick
something?
Moore, Judge.
Do I have that?
That's the one you had passed to me before you left.
I thought this was the one they said, is Mr. Moore here? Kendrick Moore?
Just needs to sign it.
Judge, I believe Kendrick Moore was a gentleman, he was in regular court.
Well,
Right. Somebody said something about him being somewhere.
4780.
Your Honor, based on the information I have, I don't know if maybe the public may want to waive his appearance. I don't have anything additional.
Right,
Then we'll waive his appearance.
I
Ask
wasn't
for an
provided
ROR.
anything.
So he is entitled to an ROR
ROR,
on one.
it's only on count one, right? Judge Canner looked like he found PC for 2, 3, and 4, no PC on 1.
Then it would just be on one.
So he'll be ROR'd on count 1. Okay? All right, thank you. See you all this afternoon.